Ever heard of renunciation? It's it's this fascinating thing in North Carolina probate law. Imagine imagine being named executor of a will,
Hmm.
but then realizing, oh no, I am not ready for this. I can't
Ah.
handle this. That's where this idea of renunciation comes in. You can actually legally step aside from managing the deceased person's estate. Isn't that wild? And here's where it gets really interesting. Let's just say someone owes a ton of money. Could they just renounce their role and avoid paying those debts? That's the kind of question we're going to unpack today. So we're diving deep into what renunciation really means and when it might be the best or worst possible move.
To kick things off, let's break down exactly what renunciation is, in the world of probate.
Basically, it's like saying thanks but no thanks to being the personal representative of an estate.
Yes.
That's the person. They're responsible for making sure everything is handled correctly, following the will, or if there isn't one.
Yeah.
According to state law, right? Like a captain steering the ship. But in this case, you're choosing to. You're choosing to step off the boat altogether. And the crazy thing is, it applies whether there's a will or not.
Yeah.
Now, I can already think of a bunch of reasons why someone might want to renounce. Maybe they live across the country, or they have a super demanding job, or maybe they just feel totally overwhelmed by the legal stuff.
Absolutely. And sometimes there can be,
Yeah.
thorny family dynamics or potential conflicts of interest. It really boils down to recognizing your limitations and making the best decision, not just for yourself, but for the entire estate.
Okay. So we've got the why someone might renounce, but how does it actually work? I've heard there are two ways this can go down. Express and implied renunciation.
Exactly. Express renunciation is all about being upfront and official. You file a specific form with the court in North Carolina. It's called the AOCE 200, and you state loud and clear, I do not want to be in charge.
So no room for misinterpretation there, but implied renunciation, that sounds a bit trickier.
It is. This happens when someone doesn't take any steps to formally accept the role within specific deadlines in North Carolina. If there's a will, you have 30 days from when it's probated. If not, it's 30 days from the person's death. If you don't act within that time frame, the court can actually interpret that silence as intent to renounce.
Whoa. So inaction speaks volumes in this case. It's like they're saying if you snooze, you lose your chance to be the executor.
Mm.
And this is exactly why. Having an experienced probate attorney in your corner is crucial. The team at Pierce Law Group can help you navigate these tight deadlines and make sure you're fully aware of the implications of each decision. Remember, whether you're choosing to embrace the role of executor or opt for renunciation, having expert guidance can make all the difference.
Yeah, it really underscores why you shouldn't try to navigate probate alone, especially when those deadlines are so strict.
Right. 30 days can go by in a flash, especially if you're grieving or just,
Yeah.
or just trying to wrap your head around everything.
Yep.
Speaking of wrapping our heads around things, let's talk about what happens after someone renounces. Who steps in? Who steps in to take charge of the estate?
That's where the domino effect comes into play. North Carolina law has a very clear pecking order of who's next in line.
So, like a line of succession.
Exactly. If there's a will, the court first looks for an alternate executor named in the document. It's like a backup plan if that person isn't available, or also chooses to renounce. The court then moves on to beneficiaries named in the will.
Makes sense. But what if there's no will? Does it turn into a free-for-all?
Not at all. North Carolina has a clear hierarchy for intestate situations, too. Usually it goes surviving spouse, then adult children, parents, siblings, and so on. Each renunciation bumps things down the line. And in some cases, a bank or trust company might even end up managing the estate.
Wow. Imagine that. Your family's estate being handled by a bank. Sounds a little impersonal, but I guess.
Yeah.
It ensures things get done.
Precisely. It's all about making sure the estate is managed responsibly, regardless of who is at the helm.
Okay. So we've got this line of potential successors, but let's address the elephant in the room. Does renouncing mean you're kissing your inheritance goodbye?
Not necessarily. This is a huge misconception. Renouncing only means you're opting out of the administrative role. You still retain your rights as a beneficiary, whatever those may be, under the will or state law.
Oh, that's a relief. So it's more about saying, I want my piece of the pie, but don't want to be the one baking it.
That's a great way to put it.
Now, what if someone has already started doing some executor tasks? Is it too late to renounce?
That's where things get nuanced. And it's absolutely crucial to talk to an attorney. They can help you assess your specific actions and figure out if renunciation is still an option. Remember, probate law is full of little details that can have a big impact.
And that's why it's always better to be safe than sorry if you're facing a tough decision. About serving as executor in North Carolina, the team at Pierce Law Group can provide the guidance you need. They can walk you through the process, explain your options, and make sure your rights are protected every step of the way. Give them a call at 919-341-7055 or shoot them an email at intake@piercelaw.com. You don't have to navigate this alone. So far, we've focused on the practical side of things. But there's another layer we need to peel back. Taxes. Could renouncing certain assets impact your tax liability?
Absolutely. This is a part of probate that most people don't even consider. You might be surprised to learn that renouncing certain assets could actually save you thousands in estate taxes. But the opposite is also possible if you're not careful.
Oh, talk about a plot twist. So it's not just about who manages the estate, but also how your decisions could affect the bottom line when it comes to taxes.
Exactly. And the IRS isn't exactly known for being flexible with deadlines or procedures.
Which is why getting professional advice is so crucial. This isn't something you want to try to figure out on your own.
Right. It's like trying to perform surgery on yourself. You wouldn't do that. You'd go to a qualified doctor. The same principle applies here. You need someone who knows the ins and outs of probate and tax law to guide you.
Okay. So we've established that renouncing isn't a get-out-of-jail-free card for your personal debts, and it might even have tax implications you haven't considered. But are there situations where stepping aside is really the best move?
There definitely are. Imagine being named executor for your aunt's estate, but you live thousands of miles away and have zero experience with probate.
Or maybe there's a family feud brewing, and being in charge will just add fuel to the fire. In those cases, stepping aside could be the smartest and most responsible thing to do.
It's about recognizing your limitations and putting the estate's best interests first, right? What if you do want to renounce, but you also want to have a say in who takes your place? Is that possible? You can actually nominate someone to take over as long as they meet the state's qualifications. It's like passing the torch to someone you trust to handle things effectively.
Okay, so it's like saying, I'm stepping down, but I think this person would be great for the job.
Exactly.
Wouldn't choosing a replacement be tricky? Like, what if the person you nominate isn't available or has their own conflicts of interest?
Those are definitely things to consider. That's another area where an attorney can be invaluable. They can help you think through the potential pitfalls and choose a replacement who's truly qualified and ready to take on the responsibility.
So it sounds like having a probate attorney on your side is essential, whether you're planning to renounce or trying to navigate
the complexities
of serving as executor.
Absolutely.
And that's where Pierce Law Group comes in. They're experts in North Carolina probate law and can provide the personalized guidance you need to make informed decisions. Give them a call at 919-341-7055 or email them at intake@piercelaw.com. We've covered a lot of ground today, but before we wrap up, let's circle back to that initial question. Can someone use renunciation to escape debts or legal trouble? That's where things get really interesting.
Yeah, it's almost like you're saying, I don't want to deal with this, but you're doing it in a legal way, and there's a process for it.
Right, so you can't just run away from your responsibilities. There's an actual legal way.
Step aside, exactly. All right, so we've been teasing this idea of someone trying to use renunciation as a legal escape hatch. Can you really just step aside and avoid dealing with debts or other sticky situations?
It's tempting to think so. Right?
But the reality is, renunciation only releases you from the responsibilities of estate administration, not from any personal debts or legal issues you might be facing. Those stick with you no matter what.
So, it's not like a magic wand that erases all your problems.
Not quite. Think of it this way. You're stepping away from the captain's chair, but you're still on the ship. The debts and legal troubles are tied to you, not to your role in the estate.
Okay, that makes sense. So even if you renounce, those personal obligations don't just vanish.
Exactly. It's like trying to get out of a speeding ticket by saying, well, I wasn't the one driving the car. It just doesn't work that way.
So if someone's hoping to pull a disappearing act by renouncing, they're in for a rude awakening.
Definitely. In fact, trying to use renunciation that way could even backfire. The court might see it as an attempt to shirk responsibility, which could lead to even bigger problems down the road.
Wow. So it's not just ineffective. It could actually make things worse. It really highlights the importance of being upfront and honest in these situations.
Absolutely. Transparency is key. And if you're ever unsure about the best course of action, talking to an experienced probate attorney is always the smartest move.
Couldn't agree more, especially when it comes to something as complex as probate law. And speaking of expert guidance, that's exactly what Pierce Law Group provides. They can help you navigate all the twists and turns of probate, including renunciation, and ensure you're making informed decisions that protect your rights and interests.
I've seen it all, and can provide the kind of personalized advice you just can't find anywhere else.
Absolutely. If you're facing any probate-related challenges in North Carolina, don't hesitate to reach out to the team at Pierce Law Group. You can give them a call at 919-341-7055 or shoot them an email at intake@piercelaw.com. They're ready to help you navigate this complex process with confidence. Bang. There you have it, renunciation in North Carolina probate law. It's a powerful tool that offers flexibility, but it's definitely not a free pass. To escape personal obligations, we've explored the hows, the whys, the potential pitfalls, and even the surprising tax implications, hopefully giving you a clearer understanding of this fascinating legal concept.
It's all about
Yeah.
making informed decisions and knowing when to seek expert guidance.
Couldn't have said it better myself.
Yeah.
Remember, every estate situation is unique, and there's no substitute for personalized legal advice. So if you're facing tough choices,
How about serving as an executor or dealing with renunciation? Don't go it alone. Reach out to the pros at Pierce Law Group and get the support you need to make the best choices for your situation. Until next time, keep diving deep and stay curious.
it really is.
So let's dive into some common mistakes that
Yeah.
people make when it comes to renunciation.
Oh yeah, there are definitely some pitfalls to watch out for.
Like what?
Well, one of the biggest ones
Hmm?
is missing those deadlines we talked about. Remember, 30 days can go by pretty quickly.
Especially if you're dealing with a lot of other things.
Exactly. And if you miss that window,
Yeah.
you could be stuck with the role, even if you don't want it.
Oof, that's not good. So what else should people be careful about?
Another common mistake is not filling out the paperwork correctly. You know,
Yeah.
the AOC E200 form we mentioned earlier. Yeah. I can imagine that could cause some headaches.
It definitely can.
Yeah.
It's really important to make sure everything is filled out accurately and and filed properly. Otherwise, the court might not even recognize your renunciation.
So it's all about dotting your I's and crossing your T's.
Exactly. And speaking of being precise, another mistake to avoid is being unclear about your nomination. If you're choosing to nominate someone to take your place, you need to make sure their information is correct and complete, and that they're actually willing to serve.
Right. No point in nominating someone who's going to turn around and renounce themselves.
Exactly. It's really important to have a conversation with your nominee, make sure they understand the responsibilities involved, and that they're fully on board.
So
Yeah.
it sounds like there are a lot of little details that can trip people up.
There definitely are. And that's why I can't emphasize enough the importance of having a probate attorney to guide you through the process.
Couldn't agree more. A good attorney can help you avoid those costly mistakes and ensure that everything is handled smoothly. And that's where Pierce Law Group comes in. They're the experts when it comes to North Carolina probate law.
They really are. They have a deep understanding of the process, and they're dedicated to helping their clients navigate it with confidence.
So if you're facing any probate-related challenges, whether you're considering renunciation or you're already serving as an executor, don't hesitate to reach out to the team at Pierce Law Group. They can provide the guidance and support you need to make the best decisions for your situation. Give them a call at 919-341-7055 or send them an email at intake@piercelaw.com. They're ready to help, and they're happy to answer any questions you might have.
Well,
That about wraps it up for our deep dive into renunciation in North Carolina probate law.
it's been a fascinating conversation.
It really has. We've learned a lot about this unique legal concept, and hopefully our listeners have too.
I think so. It's definitely a topic that everyone should be aware of.
Absolutely. Because you never know when you might find yourself in a situation where you need to make a decision about serving as an executor or renouncing your role. And when that time comes, it's important to be informed and to have the right legal guidance.
Couldn't have said it better myself.
So, if you're ever facing a probate challenge, don't hesitate to reach out to the professionals at Pierce Law Group. They're here to help, and they'll make sure you're protected every step of the way. Until next time, stay informed, stay curious.
And as always, thanks for listening.